Yes.
For serving a copy.
I'll
You
serve.
serve him a copy
Right.
and you are asking for an adjournment. He will take instruction
Right.
to serve him a copy. Is when third
Let him serve a copy on today.
and serve the copy in course of this day. Morning.
Item number 5. Item 5.
On shop license.
My lord.
On shop license.
On sorry, it has already been.
Why it has been cancelled?
No, cancel, my lord. The opposite party 6 is the opposite party 6 who is running the license on shop under the petition of the premises, which has been expired since 13th November 2024. Now he is forcibly occupying the premises, saying that I must continue my business. The license is.
Who are you?
I am the petitioner. I am
No,
the petitioner. I am the
no, you are a
landlord.
petitioner. Who are you? What is your relation with the premises?
My lord, I am the landlord of the tenanted premises, which is already expired since last 13 November 2024. I have submitted a representative to collector Khordha, which is pending on the annex of 7 and 6 and 9.
Sir, what is your prayer in the writ petition? Tell us.
My prayer is also kindly see,
Just to throw him out.
no, Ramit, because her license is going to expire on 30th March, 2 days thereafter.
So-
Because she has involved many untoward incidents during the occupancy of the tenanted premises. My lord, I represent the collector so many times.
No, it's
Not
a
to
dispute
extend.
between the landlord and the tenant,
Yes,
and you want that we should direct the collector before whom you have filed the representation to come to you and settle.
no, that is not my.
Personal score.
No, my lord. My humble submission is, she has filed as many as case against me not to vacate the premises. I appealed to the collector. So kindly reconsider my grievances. There is a rule, the lordship kindly, rule 44 of and 45 excise rules, but I specifically proposed.
Sir, there are under the excise rules, once they have granted a license, then at the time of renewal of the license, they will definitely take into consideration if there any objection has come, they will take into account the objection.
Yes, ma'am.
That does not mean that you will approach and say that don't renew the license. It is within the competence of the authority to grant or not to grant.
No, that is my grievance before lordship, because she is under my tenanted premises. I simply made a prayer to collector to consider my grievances.
What to do, sir?
My
Go and get him evicted. You do not want to enter into an
That-
agreement that they will consider.
that is not my grievance, your lordship.
Your
In-
prayer two, Proverbs 2 at page 13, you come, what you have prayed for?
I pray for her considers my grievance. When the whole first is my
Sir, you
prayer
have
is
said further be pleased to direct not to renew or extend the license due to want a registered agreement as required.
Exactly.
So you do not want to enter in an agreement with them.
No, there has been no agreement. As it is,
Dispute of the tenant and the DCP should be directed to take strong action
Sir,
against the item.
and in connivance with the police, local police, I have been put to many embarrassments, sir.
What
Because
has happened, sir? You have inducted a person as a tenant.
That has been explained, Your Lordship.
Now the question is, once the person remained in occupation after the expiration of a period,
Yeah.
then what is the remedy provided?
Remedies
It's not a
available.
Civil remedy.
Exactly, my lord.
Then go and explore the civil remedy.
She has filed a case. She has filed a case before. That is not my matter before my lord. My simple grievance is only to consider my representation, nothing else. Only consideration.
They will consider automatically, but I don't think so. You really wanted to flag your civil issue.
No.
And,
That is my intention. That is not my intention, my lord.
wanted a blessing from the court. So that is not what.
That is not my case, my lord.
That is
My
what your case is.
My case is very simple. Consider my grievance. I have a genuine grievance.
Can be directed. Once we direct the representation, it will be taken otherwise. Because it is your personal issue. You are trying to score certain score with your tenant and
Because he has violated the
get an order.
rules of 44 and 45. Because there has been no.
They will take care of that, sir. They are the authority.
Exactly.
The law.
As your lordship direct. As your lordship.
Coming into this aspect, they may ask for the agreement, whether your agreement has been renewed or extended. Everything they will take care.
Minor.
The courts sanction you require. No, that is not. You really wanted to get away with the.
No, that is not my.
That's your main motive.
That is not my absolutely no. My grievance is before a collector to consider.
The EIN is at the business of the landlord of the premises.
That is not a PIL, my lord. It is not a PIL.
Then
It is only simple grievance. That is not a PIL, my lord. Read petition.
what cannot be achieved directly is got to be achieved in an indirect manner. Taking recourse to the powers of the writ courts under Article 226 of the Constitution of India. The petitioner is the landlord of the premises, which was let out to the respondent number 6 for commercial purposes. The said respondent number 6 was granted an on-shop license by the Excise Department. And which is going to expire on the last day of the month of 2025. The petitioner's grievance in the instant writ petition, though evidently on non-renewal stroke extension of the said license, but the latent intention is to get away with the tenant from the premises, where the said shop is being run on the basis of the license. The approach has been made to the Excise Department, ventilating the grievance, preempting that the license would be renewed / extended. But till date, no decision has been taken by the Excise Department. And therefore, the writ petition merely on the basis of an unsubstantiated apprehension should not be entertained. So far as the grievance of being in possession of the suit premises without the renewal and or extension of the period of letting is concerned, in our opinion, it is a civil dispute. And it is open to the petitioner to approach an appropriate forum in this regard. Since the authorities have not taken any decision, we do not think that the prayers made in the writ petition warrants deserves to be allowed. And therefore the writ petition is here.
My lord, beg to mention another item 24 of Orissa, the opposite party.
My lord, I am item 24. The tenant over that suit property. That item is
Be happy with the tenant.
my lord.
Oh, you want your name to be recorded?
No, my lord. I have an item under 24. Item 24. Same schedule of property. I want to renew my license.
24 of the excise.
My lord.
This map 24 is not marked.
So why they will be deprived of their appearance?
My lords, it was mentioned. My lords, it was mentioned, this-
Item 6 and 7.
6 and 7.
Item number 8.
May I please your lordship? That the petitioner is a license for the IMFL of shop of Kodara 2 shop, my lord. And
With the
IMFL of shop license, of shop license.
Yes.
And there was some shortfall of the MGQ for the financial year 2023-24, for which this shop was locked on 31st March 2024. Thereafter, the petitioner approached this honorable court in WPC number 13644 of 2024 And as per the interim order, my lord, under annexure 3,
You have
Yes.
to deposit the 50%.
50% of the demand, and, then thereafter the license was issued. Thereafter, my lord,
Deposit 50%
He-
of the demand.
it deposited and the license was issued, and that is at page 26 of the writ petition, my license.
Again, you have defaulted.
No, my lord, I have not defaulted.
Eh?
Now, what happened, the license was issued on 30th November 2024. Now they have demanding the MGQ for the closure period, that is 1/4/2024 to 30th October 2024.
Then you have to pay.
My lord, that was
If you were
closed.
allowed, that was an interim arrangement which was done, that you just pay off the 50% and then now you continue lifting the. goods. Now
Yes,
you
my lord.
continue. But that default remains, then.
No, I am not disputing the default of the 2023-24, my lord.
Then,
Then from 1/4/2024 till the opening of the shop, that was closed by the excise department itself.
when they have lifted that, order.
That by using the license on 30th November 2024. Can I have glance to the page 28 of the brief, my lord? Last two line.
Yes.
The lifting of MGQ of IMFL and beer of the shop from 1/4/2024 to 30th 10/2024 by the licenses shall be subject to the final outcome of the WPC number
What
136.
is pending?
That is pending.
True.
Now they have given me a demand notice, my lord, under annexure 5 for that period.
Uh, where is that?
Annexure 5, my lord, page 29.
Yes,
Yes, my lord, my lords, if I may refer to annexure 3 once more,
madam, if, when you review the license, at page 28, you said that the lifting of this is subject to the result of the repetitions. And the repetition is still pending, where the interim order was, granted that if they deposit 50%, you will permit them to lift. Now you have raised the demand. So that it has to be adjudicated, that whether the demand can be sustained, justified or not. So to make the demand and then put a spanner into his lifting of the materials, then
my lords, I'll take instructions to that effect, my lords, because this matter, if I can refer to para 1 of the order,
You have deposited that 50%.
50% thereafter license was issued.
my lords, I'll take in.
coercive steps to be taken on the basis of a show cause notice dated 2/3/2025 issued by the Excise Department on the petitioner, raising a demand for a shortfall of minimum guaranteed, what is this?
Quantity,
MG
Q, quantity.
for the financial year 2023-24. The present writ petition is filed. The petitioner could not meet the minimum guaranteed quantity for the aforementioned financial year, which did the cancellation of a license. Stop. The approach was made to this court with WP within bracket C number 13644 of 2024. And an interim order was passed on 4th November 2024 to the effect that the petitioner will deposit 50% of the demand within the specified time. And in the event of such deposit having made, he may be permitted to lift the corresponding quantity on his license appropriately renewed, subject to the compliance of all formalities. The said writ petition is still pending before this court. Since the petitioner complied the directions passed in the said writ petition, the authorities renewed / extended the license, subject to the conditions that the lifting of the MCQ from 1/4/2024 to 31st October 2024 shall be subject to the final outcome of the pending writ petition. According to the petitioner, amidst the pendency of the said writ petition, the authority should not raise a demand for such period where the license which was renewed in terms of the interim order was subject to the final outcome of the said writ petition. The state intends to take instruction and trade accommodation. Let this matter be listed the second week of April, anytime. In the meantime, no coercive steps would be taken on the basis of the impugned notice.
Item 13 also similar manner. Item 13(1)(3).
On 3, same.
Yes, my lord. Yes, my lord, similar matter.
Well, Ramesh is also same.
What is the date of the focus notice?
So they are not issued any so cause notice, but orally they have demanded.
By overall.
Sir, sir.
See,
Once you say
like
same,
in order.
Let it reach my lord.
Apprehending any coercive
Yes,
steps
sir.
to be taken, the present writ petition is filed. So it does not appear from the writ petition that any attempt is made by the department to take a coercive steps against the petitioner. The writ petition appears to be premature.
Let it reach my lord. I will demonstrate my
Let it
lord.
Go and if the show cause notice is issued, come back. It's premature. The same is hereby dismissed. The dismissal of the writ petitions and not prevail. The petitioner to ventilate his grievance in the event the cause of action arise in this regard. At liberty, we have the already given.
Well,
Item 9.
9 my lord. Yeah.
Fine. Similar.
No, my lord. Here is a, it is a OS of my lord. Country, hostile manufacturing unit, which was
The country liquor.
country liquor. It was settled in the month of November, my lord. In the month of November 2024. Under annexure 1, my lord, license was issued on 31st/7/2024 up to 31st August 2024. But on the annexure,
You voluntarily close the shop.
no, my lord, I have not voluntarily closed, my lord. Annexure 2, immediately on 2nd August, they have kept the license in events, my lord. Last paragraph. At page 12, page 12,
Page 12.
my lord.
Yes, kept in abeyance till 31st of August 2024.
24.
Then,
Then thereafter they have asked me to search for a new site.
okay,
I have given them a new site that was approved. Thereafter, the license was issued again. In the month of February 2025, my lord. Now they have demanding the,
Which is that February letter,
my lord,
February letter is annexure 5.
annexure 5, my lord,
first February.
my lord.
No, you were directed to find out a suitable unobjectionable site in the sanction.
Never. Thereafter, my lord, I have find it out. They have issued me the license next year, my lord. Annexure 6 series. Now what happened, my lord? Now they are demanding the MGQ for that closed period, for which the license was kept in abeyance. For which I have already submitted a representation before the authority, that is annexure 7, page 23.
What is the demand?
Not demand, my lord, again oral, for which I have submitted the representation.
Make oral demand.
Now they are saying they orally on the at the 12th, 11th hour of the month of March, they will serve with the demand notice. For which I have already submitted the representation and I have sent it through registered post, my lord.
You are not liable to for any MGQ prior to this one, so.
Sure, sir, ma'am.
Where is the demand?
They have not served any demand notice by verbally.
My
They have
lord,
said that for which I have to submit this representation, my
My
lord.
lords, in this representation only, there is no reference to any demand asked by the department.
Let them take, they
Like-
may not raise demand, say, why you have come again?
Because we are apprehending that on the 31st they will
Then
close.
once it is stayed, then you come, the cause of action has not ripened as yet,
Because,
in the same, earlier on.
well, let them take a decision.
Liberty to approach.
Well, let them take a decision on my representation at least.
Necessarily on something in vacuum. They have not raised the demand. Now you are really flagging an issue and making them aware to raise the demand.
They will definitely raise a demand on the very last moment.
No. After that.
Item 10.
May please, your lordship. Now here the petitioner has challenged the notice under annexure 5 at page 23, Lord.
Page,
23, Lord. Annexure 5,
23.
yes. Lord.
what is this?
Not here they have,
Offshore.
yes, Lord. I am also not a off-shop licensee, but this Bomical I am also off-shop. Now they are by way of shifting, is coming to my area. Now, this notice has been issued in violation of Rule 24 proviso. Lordship, can I have a glance, Rule 24.
My lord, in this case,
Yes, madam. My here submission is that before issue of public notice, as per Rule 24, they should take the prior approval of the government. They have not obtained prior approval and they have issued, this collector has issued public notice. Lordship, kindly have glance, it's Rule 24 of Odisha Excise rules. No, there is no provision. Post facto approval provision is not there. But it is there, it's prior approval. It says prior approval, Lordship. Yes, 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 Lordship. It's prior approval. Prior is what is there.
my lord, in this case, I have filed an intervention petition that has not come. My lord, because I have filed the application for sitting. I am a necessary party, but I have not been paid.
Yes, madam. Well, I have got a copy, copy, I'll handing over that. Lordship may allow that. Inadvertently, I have not given.
Application IN number 5231 of 2025. That has not come to the, yesterday I have filed that.
Yes, ma'am. But I am serving writ copy. Copy of the writ petition I am serving. Yes, ma'am.
31
Lordship.
of 2025.
No, I have handed over the writ copy. Lordship, taken up next week.
The grievance of the petitioner, my lords, is the grievance of the petitioner, my lords, in a notice under section 73 of the Value of GST Act, my lords. They have also demanded late fee under section 47 and general penalty under 125, my lords. As your lordship knows, my lords, section 73 contemplates about taxes and if there is a difference in input tax credit.
Now again, he will take a shelter of 128A.
Lords, 128.8, Lord, unfortunately, does not apply for late fee and general penalty. Late fee only applies for taxes, and there's a waiver of penalty and interest, Lords.
Seems to, your lordship, trying to say there seems to some error. But your lordship, there is ambiguity in the statute. There seems to some of the provisions so far as that 47 is concerned. There is some ambiguity there. I have gone through all the provisions. Your lordship, let me take instruction because your lordship may kindly turn to 2 to 3 provisions. There seems to some ambiguity. Section 44, your lordship, the annual return.
Yes. Better do one thing.
Your lordship,
Prepare a compilation thereof.
your lordship,
Come on the next day.
let me take instruction. It seems there's
Yes.
there is some error on.
When you are
our
fair
part.
enough in this
Yeah,
regard, let us. When
Your lordship, 2 weeks, 1 week after.
So I've just prayed an interim, in the interim since month of March, my lord, your lordship would appreciate. Let them not take, let them not precipitate, my lord, and
We'll take
enforce.
care of on the last. on the
Annexure
side.
2, your lordship, is some protection.
We can take care of. What do you say?
Interest and penalty, he has already paid the tax.
I have already paid the tax, the interest.
That is why the only thing is the imposition. So that will be taken care of in the month of April, no problem.
The problem, my lord, is they attach my bank guarantee at the drop of the hat. my lords.
No, they have said that they will not. Don't
I'll
pay.
immediately put an issue.
Yes, please, I request them. We are not passing any order, but
Your lordship.
the state pays for an accommodation to take an appropriate steps, appropriate instruction in this regard. As several documents are required to be collated.
Oh, okay. No,
Stop. Let this
thanks
matter.
for the good lecture.
Well,
Lords, today in the morning, I'm informed they have already issued an attachment order. Unfortunately, they have not enforced it. So let them not enforce, my lord, the demand, lords.
take care of that.
Your lordship.
They have issued that attachment order.
They will take care of that. When he's there.
Some indication, my lords, at least.
What is it? Yes, this is the matter on 9th or 10th, what?
Whichever date is convenient for your lordship.
No,
Your lordship, it may be 10th, your lordship.
to be very frank, every day is convenient to me.
No.
Provided you come and argue.
Your lordship, 10th.
10th.
So knowing your lordship's roster, my lord, we have the obligation to at least leave it to your lordships for fixing of the cases.
All-
Your lordship.
Item number 14.
I believe, my lords, my learned friend
Oh,
will take
yes,
care,
yes.
my lords.
When he has assured, he's a very responsible.
No, he's a very fair counsel, my lord.
Yes,
I do admit.
No doubt, every council is very fair. Don't
Your lordship.
Obliged, lords.
Item 14.
May it please your lordship, my
Yes.
lord, I seek an adjournment of 1 week after your lordship. Learned senior counsel was supposed to come from Jharkhand. He is unable to make it, unfortunately. Only 1 week after, I kindly request for an adjournment.
Why did you circulate? Other side is here. You could have informed.
My lord, it came
Here
up
the
suddenly.
order, here the order has been
He's
passed.
asking for an adjournment, senior counsel. When, next week?
My lord, on 10th of April, if it is
How this seat is maintainable, like, kind of. Your lordship.
obliged. You.
Item number 17.
This,
But this is a matter where the petitioner is challenging order passed by the government rejecting the petitioner's application for grant of on-shop license. Before I take on-shop license.
on shop license.
Right. Before I take my lords to the impugned order involved here, the lordship will find that from impugned order, the government precisely on 5 grounds has rejected my application. out of which 4 of the reasonings are covered by the judgment passed by this honorable court, by recent judgment passed by this honorable court. 1 point is not covered. That I am required to answer, my lords. If your lordship will turn to page 22, that's the
There is no other forum to challenge. this
big
order.
part. No, this is passed by the government, madam. This order is passed by the government.
Yes. That's
So but if it would have been by the commissioner, then revision. But the order is passed by the government, therefore. In this case, the petitioner is a licensee since 1982. He was operating over the self-same location, self-same shop since 1982. But 2021, government decided to hold lottery for all these licenses. Petitioner lost in the lottery. That is how he could not get the license after 2020. So what the petitioner did, thereafter he wanted to open an on-shop because previously it was off-shop, means sale in a shield position. Now he wanted to open an on-shop, applied for the same. There was inquiry taken place. Consequent of an inquiry, collector recommended, commissioner recommended. Now, couple of occasions, petitioner had earlier approached your lordship. Your lordship has been pleased to quash the government's order. First one occasion saying that it is without any reasons. Remanded the matter back. After remand, government has passed this order. Your lordship will see all these reasonings given in the order. 4 out of them are covered by the judgment which I have just now given, and one is that your lordship will see proven demand rule 29. Proven demand aspect, government has committed an error of record over there. Government is saying in the impugned order that there are 4 shops operating in the same vicinity, which is not a fact. In this very same order, government is saying that there are 3 shops operating, and the main objector is no more a licensee. The objector who was objecting my license, off-shop licensee, as on date, he is no more a license. So the government should have taken that into consideration while passing the impugned order.
So have you pleaded the objector as a party here?
But objector is no more a licensee. He is no more a licensee. So he is not required to, his objection is no more valid.
in the page number 21, that is the internal page is 2. It is mentioned that in response to the same 2 objections were.
Oh, sir, the objection of my sister has been overruled by this honorable court in one of the judgment. She is not challenging that. So that is no more there. The objector given by one of the licensees, he is not continuing as a licensee anymore.
Whatever is there, but his presence is necessary because he has at one point of time raised an objection.
Look.
Your sister, I understand that you came before this court and that this court has
Correct. Correct.
passed
Correct.
that for objection or did not accept.
But I don't mind impleading him as a party. But I'll implead him, Paji. But
You have to implead him a party.
I'll implead him as a party, but to cut it short, to avoid any further delay, can the government also in the meantime take instruction and come back to your lordship in the meantime?
That
I'll
the
take
government
instruction.
will always do.
That's what I'm. Meanwhile,
The writ petition is filed. Setting the decision of the government in not granting the online on-top license to the petitioner. It appears from the impugned order that the inquiry was conducted on the basis of an objection raised by 2 persons. One of the objector being the sister. So far as the objection filed by the objection raised by the sister is concerned, according to the counsel for the stuff, the same has been turned down by the court, by this court in an earlier round of litigation. Since the other objector is not implemented as a party, any order would affect his right, and therefore we find him as a necessary and proper party. The petitioner is directed to implead the other objector as in the category of the respondent here. The petitioner is also directed to serve the copy of the writ petition upon the added respondent. By speech pause.
Right.
Or what?
Speed post.
By speech pause. And shall find the affidavit service. In the department.
Right.
Annapurna Parikh is your sister.
Sister.
What happened in the earlier litigation, you said?
The earlier litigation, that very objection was overruled by the Honorable Court saying that
This is the matter when.
right. Great.
Can it come on 15th or 16th, my lord?
By Monday, my colleagues will take steps. By Monday, they will take steps. I'll do that. By Monday, everything will be done.
May I please, your lordships. Your lordships, the first appellate authority reject the appeal on the delay ground without considering the rectification of error period. Your lordships, in this case, assessment order is passed on 30th August 2024. Therefore, petitioner preferred the first appeal on 3rd of September 2024, which was rejected on 26th December 2024. Petitioner filed the first appeal on 1st January 2025. Thereafter, without consideration the period of rectification of error, your lordships, they technically reject the appeal on the delay ground, your lordships. 1 month.
1 month delay.
1 month, your lordships.
Your lordship, here the delay may not be condoned. Here, your lordship, his grievance is that there was assessment order has been passed, and subsequently he, without going to appeal, he has filed a rectification application under section 161. So against, after that, your lordship, after passing that, he has filed the appeal. So according, exactly, that is to be, I have to look into that, because in the appeal order, there is only the assessment order, adjudication order has been mentioned. So perhaps the rectification order has not been mentioned. So if he has attached that rectification order, then there will be no delay. Admittedly, there will be no delay. Your lordship. So only because he has not annexed that appeal form or grounds of appeal.
Give the document, what are you doing? Have you
Memorandum of appeal.
Yes, next date.
Let him submit the memorandum of appeal.
Yes, sir.
Item 21.
May I please, your lordships? Lords, impugned is the consolidated order passed under section 74 of the GST Act, your lordships, on 29th January 2025, your lordship, annexure 2. Lords,
annexure
2, lords, running page 30. Lordship, this impugned order, your lordship, is pursuant to a consolidated show cause notice issued under section 74, my lords, annexure 1, my lords, covering multiple assessment financially, your lordship, 17, 18,
1920.
It is really a consolidation of the several.
Yes, my lords. Yes, consolidated.
Common order.
Yes, my lords. My lords.
Common
My lords. Yes. My lords, my humble submission to your lordship is that your lordship department cannot issue, my lords, cannot group multiple tax period into a single show cause notice, as my lords, each assessment year must be assessed independently, your lordships. My lords, similar issue, my lords, this honorable divisional bench of this honorable court, your lordships has my lords, directed the department to file counter affidavit, similar issue, your lordships.
We'll take instruction here, file that.
In 3 weeks, your lordship.
Yes.
3 weeks.
Okay. So by 2 weeks,
3 weeks, your lordship.
3 weeks, is under 1 week thereafter,
Yes.
1 week thereafter. This is the matter of the program.
Item 22.
May I please your lordships? My lords, impugned is the notice of demand under section 156 of the Income Tax Act, your lordship, annexure 1 series, page 16, my lords. My lords, this is relating to assessment year 23-24, and lordship is pursuant to an assessment order passed under section 143.3, reduced section 144B of that. My lords, challenges is on the ground here, lordship is limited there. My lords, without considering, my lords, my prepaid tax that has been deducted by the deductor, your lordship, TDS.
File an appeal.
My lords, it is an admitted fact. I'm not challenging to the assessment order, your lordship. It is an admitted fact, your lordship, only notice of demand. My lords, admitted fact, I have paid prepaid tax as well as your lordship TDS. My lords, even
Yes, what he's saying.
Your lordship is saying that assessment has been completed. First of all, he filed a return. Then after that, he filed a revised return.
On 143 and then the revised one.
Then the file was taken into scrutiny. After the scrutiny of the file, the demand has been created without considering the tax which he has paid.
Yes.
So that is the only issue is here.
So that
I
means you
will-
have to take an instruction and say, if it is already paid, then
I'll
how
take it.
can you, then you have to withdraw.
If he's not challenging the assessment order,
He's
only
not-
for the refund, only for the tax paid adjustment,
Right.
I'll take instruction, accordingly, if it will
If
be
you
adjusted.
want it, come in the next week, tell us if it is, he has already paid
Yeah, lordship.
the entire demanded amount. Then,
Yes.
just say, why you are proceeding? When,
With 2 weeks, your lordship. It is a faceless it's the assessment is
yes,
done by
2 weeks.
faceless to.
you have to take instruction.
my lords,
Let him file a
my lords,
rectification.
no
petition.
corrective action, my lords,
Lordship,
for recovery.
Yes.
Your lordship, let him file a rectification petition that will be taken into consideration by.
Why rectification?
Okay,
sir?
Lordship.
Fault is on your part. Why you will file a rectification?
Oh,
Deeply.
Item 24.
Your Lordship, in this case, petitioner is a running on-shop license,
Onshore.
on-shop bar cum restaurant. And she was tenant under OP number 5. Thereafter, my lord, under annexed, my lord, 10, my lord. Government of Orissa issue a letter stating therein that those who are renewal for the license, valid registered deed is required for agreement. Those who are
What is civil pending and
rented premises running in the shop, they are required for the registered deeds deed. Thereafter, my lord, suit is filed by the petitioner before the court below. And
For what? What relief? For what relief?
for the suit for permanent injection against the suit for permanent injection against the owner. Suit is pending and
What permanent injunction? Not to evict you from the
My lord,
premises
my
without due process of law.
my lord.
So any injunction is granted there.
No, my lord, suit is pending. I also is
Correct.
pending.
So if that being the position, they wanted a registered agreement to be annexed with
That is
this.
requirement of Rule
So
51.
if it is a requirement, then we'll
My
have to
lord,
give.
that registered agreement is lost by the conducting council in court below.
Sir, you can get the certified copy from the
My lord,
registered authority. It's a registered
My lord,
agreement, it's a public.
My lord,
You get it.
under annexed 1 is a registered deed. Thereafter, subsequently, another rent agreement that is notarized. That is not registered one.
Sir, if the requirement is that there should be a registered agreement, then you will have to follow that requirement.
My lord, owner
Or
is
he
a
can give an
disputed
undertaking,
situation.
my lord, that if registered agreement is not there and he has made application for renewal, before grant of year, he has made the undertaking for the true owner that he has to submit the registered agreement in course of
Subsequently.
time.
My lord, suit is pending. Now the dispute is continue. In this situation, owner is not willing to make and register agreement with the
Have to.
My lord, in this led one of the judgment of Appeals Court, section 65 of the Evidence Act, for the
65 of the Evidence Act.
Evidence Act. My lord, when the original has been destroyed or lost, or when the
Sir,
party,
this is, you can lead a secondary evidence.
my lord,
That is in
my,
a civil suit. Sir,
My
kindly
lord.
visualize, don't get, confused with this. When you are before the civil court, then you are supposed, the onus lies on you to prove the fact by virtue of section 102 of the Evidence Act. Now, there are two kinds of an evidence. One is a primary evidence, another is a secondary evidence. If the primary evidence is not available, then you can lead a secondary evidence. And in order to lead a secondary evidence, there are certain requirements under section 65.
my lord,
So that you can prove it before the civil court. But here, you have applied before the authority for renewal or extension of the
my
license.
lord.
Their requirement under the statutory requirement is that you must annex the copy of the registered lease agreement or a rent agreement, whatever.
My lord.
Now, if you do not permit, then the only, I would say, the exception which he has said is that if you can give an undertaking of the landlord that I will execute the registered agreement subsequently, then they can proceed on that understanding or indemnity which is given. But they can't dispense with the requirement, the statutory requirement. You'll have to follow. Follow Nazir Ahmed's judgment of the Privy Council.
Right.
EIR 1926 Privy Council, Nazir Ahmed.
My lord, I have a
26
reprinted,
or 26.
my lord, I have a file and representation. Basic upon the said judgment may be disposed of the.
What?
I have a file and representation.
Now the Supreme Court has in some judgment has says that the court should not pass the order of consideration of representation when the court finds that he has no sustainable right. Why unnecessarily burden the administration? If the requirements are not met, you can't.
My lord, petitioner is a lady and she was invest more than 2 crore over the suit premises.
Yes.
Petitioner is a lady, she was invest the more than 2 crore of money for the said premises. If the extension of renewal is not continuous.
You have
Yes,
to
of course.
follow the mandate of the law. You can't get away with that. Maybe there is a dispute. I do not know. It is up to you, is your wisdom to take a decision what to do. But the authorities are bound by the law. They can't transgress the law. Can we pass a mandamus directing the authorities to act beyond the provision of law?
Petitioner, first of the party, challenging for a direction to accept the application along with the notarized agreement for renewal of excise license for opening of the bar from restaurant of the petitioner for the period of 1 year as civil suit number 2086/24 and CS number 72 of 2024 are pending before. Which court it is pending?
My lord, one suit is filed by the petitioner, another suit is filed by the landlord.
For eviction? For
Well-
the review, removal?
My lord, for the eviction.
For eviction.
My lord, CS number
Yeah.
2086 is a petitioner of 2022-24.
Prior portion, both the case numbers have been
You
mentioned.
are not giving the name of the court, that's why we are asking you, which court it is pending?
My lord,
You
civil
asked-
judge junior division.
Huh?
Civil judge junior division, my lord.
Which court, which, where?
Bhubaneswar.
Division,
Bhubaneswar.
Bhubaneswar. Both the cases are.
One is senior division and my case is pending civil judge junior division.
Which case?
My lord, 2086 of 2024 is pending before civil judge junior division.
Civil judge junior division, Bhubaneswar.
My lord,
And what about CS number 72 of 20?
that is pending before civil judge senior division, Bhubaneswar.
Second additional senior civil judge,
Civil judge senior division.
that is page 56, my lord. That both are
All right.
annexure 6.
It is the case of the petitioner that is a bona fide license holder. Right, manual license number 70 of the 2019-20. And was the proprietor of Messrs. Barbie Restaurant and Bar, which is situated at Bhubaneswar. And both the petitioner and the opposite party with the landowner entered into an agreement for rent on 11th of November 2019. And which was registered before the sub-register Bhubaneswar. And security deposit was given to the opposite party number 5, and monthly rent was also paid. And the tenure of rent was for a period of 5 years. That is from 11th November 2019 to 15th November 2014. 24. It is the, for the case of the petitioner, that a dispute arose between the petitioner and the landowner, for which the petitioner filed CS number 2086 of 2024 for permanent injunction against the opposite party number 5 landowner, and the opposite party number 5 also filed CS number so on so against the petitioner. What is the relief claimed by the petitioner for eviction? For eviction. Both the cases are sub judice in the before the civil courts as I said. In this the case of the petitioner that since it would be difficult on the part of the petitioner to get the, what is that document?
My lord, under annexure 2, that is notarized rent agreement.
Registered lease agreement from the opposite party number 5 in view of the pending litigation. The opposite parties may be directed not to insist upon production of such document for renewal of the license or renewal of license. Since the land council of the state on the other hand submitted that it is the requirement of law that in order to grant renewal of the license, the petitioner has to produce the lease agreement, the registered lease agreement before the lease agreement or the lease agreement or the rent agreement before the rent agreement before the authority, and that cannot be dispensed with. Law is well settled as held in case of Najir Ahmad 36 Privy Council 252 that when something is to be done, a law prescribes something is to be done in a particular manner, it should be done in that manner or not at all. When the statute requires that the petitioner has to furnish the sponsor documents, this court, by exercising the power under Article 226 of the Constitution of India, cannot direct the authority to act in a particular manner which is not permissible in the eye of law. Therefore, we are not inclined to interfere.
For orders item 24, sir.
We are just coming in.
Orders item number 25.
Item 25, 27, and 28 and 29. There is a common issue involved regarding block grant teachers claiming pensionary benefits. Now, the lead matter, the lordship, is WA 197 of 2024. So all these, that is not in the list. These 4 matters may be tagged up together, clubbed together, and may be listed along with WA 197 of 2024.
190.
I'm giving.
25, 27, then 28,
25, 27, 28, and 29.
You are for?
I am for the state.
Or the writ petition?
State is for the appellant. State is for the appellant. State
State is for the appellant.
My
submitted by the counsel appearing for the appellant.
Well,
That the issues involved in the instant petition is identical and similar to an issues involved in
WA number 197 of 2024.
which is not listed today. Since the common issues are involved in all the matters, let the instant matters means 25, 27, 28, and 29. Be tagged with WA, what he has given.
Number 197 of 2024.
And we heard analogously. When you want, and
1 week after, any date, 1 week after.
this is the matter after a week. Give or take. Give or take. In the meantime, you inform the other side.
Other side.
Item 26.
26, my lord, may I please your lordship, my lord, I may be permitted to take fresh notice against the respondent number 1 and 3 in correct address within 3 working days.
Take down that the land and council for the, you are for the appellant, no?
Petitioner, my lord.
Yeah.
Petitioner, my lord.
Petitioner means appellant. read
My
the
lord.
And counsel for the appellant submit that since the notice has returned unserved and the address could not be located, he may be permitted to take fresh notice and you would furnish the correct address. How much time you require?
One,
Furnish the correct address and also file the fresh requisites, means postal requisites, that unutilized copy will be utilized.
well,
So what time you,
like 3 weeks.
correct address means you have to depict where that person is now. Because he is not staying in that address. 3 weeks.
Well,
Item number 30.
30, my lord. Earlier, we filed one interim application with a prayer for dispense.
That is not.
Along with the appeal, my lord, I filed 2 interim applications.
So the notice is sufficient because postal.
My
tracking
today-
input shows that
Yes,
item
yes,
has
It's
yes.
not I am
been-
appearing.
Yes, my lord.
Today, my lord, I am appearing. Today I am
So you are
appearing,
appealing?
my
So what do you want?
I have already filed an objection to the IA.
Delay condonation
Delay
application.
condon- my-
Have you served a copy?
No, no, copy you have sent.
He has not received. Please serve.
He says
Today,
the
today, my
office
lord, I
is
am
out.
Let's take down. Mr. Partico, please give the name.
Ma'am.
Submit that he has, you have already filed Wakanatha. Submit that he has filed Wakalatnama. Let the registry place the Wakalatnama on record. The name of the land and council be reflected in the cause list. Land council submit that he has already filed objection to the delay condonation application. State council submits that the copy is not available. There's a press copy we supply to the land council for this state. Matter will be placed next week or the week.
1 week after.
1 week after. So give a date so that it will come for the consideration of the interim application for condonation of the. 1530. 1530.
Item 31.
Please, ma'am. My lords, I filed this application for interim bail on behalf of the appellant number 2, whose sister was a widow without children and residing in his house because of
What is your instruction then?
instructions there on record, my lords, on Monday.
What is, have you ascertained the veracity of the statement which they have done,
May I place the instruction?
lease.
Yes, sir. Where is the instruction?
Which page? Where is the instruction?
I think that has been filed on Monday. The instructions.
Not been scanned.
Okay.
Yes, your lordship has quoted it in your lordship's order.
May I read it? please?
Staying with this appellant, the father of police or everyone in the family. Present by the family. Custody of valid so that is correct document. Then, Mr. Panda, what is the allegation against you?
Allegation is of murder, my lord.
302.
302.
302 with 34.
Which district?
Yes, Dhenkanal. Rasor.
No problem once.
That was
Obtain instruction that if he is let out on.
inter-family dispute between cousins.
Yes.
There is no such problem of law and order.
Main,
Oh, once
There
you
may
are
be, Your Lordship.
taking this instruction, please take also this instruction. Because it's a family dispute. Right?
Yes, my lord.
all the accused person and the deceased family, they are co-villagers.
Dispute
There
between
was this-
cousins who are neighbors.
And the appellants killed the deceased due to a trivial issue.
Yes, yes. Your lordship has granted me parole twice. my lord.
Twice you have been gone.
My lord's mercy order dated 3/2/2020.
3/2/2020.
No, 25 to 20, 26 to 2020. 6 February 20th, 20,
Of this 26 to
2020, my lords.
2020, that is first interim day.
Yes,
Then second.
my lords. They are not
This was the
interim.
only time he was granted bail by the justice.
Bail by this court.
Yes, ma'am.
Might have been granted by the authority.
4 weeks, your lordship. granted.
Year number 903 of 2025. It's an application for interim bail. Filed by appellant number 2.
Yes, appellant number 2.
Appellant number 2. What is his name?
His name is Babuli Sahu,
Probably so.
son of Basista Sahu.
To attend the obsequious ceremonies of This is sister who expired on 22/3/2025. The certificate issued by the Sarpanch from the Gram Panchayat,
Coronda.
Coranda Gram Panchayat, that the date has taken place has been annexed to the interim application. And the matter was taken up on, have we passed any order that to verify it?
On 20
On 24th.
24th, your lordship.
That was mentioned
was
in the
taken up on 24/3/2025, the land council for the state was asked to obtain instruction in the matter. And the land council for the state has obtained instruction
On the same day.
and submitted a report from the IAC Rasol Police Station, which indicates that the deceased sister was staying with the petitioner and in the family of the petitioner. The family.
Her brother-in-law and father have attended the cremation.
This is widowed sister was staying in the family of the petitioner along with the other family members. So the Mr. Panda, land counsel appearing for the petitioner submitted that the petitioner has earlier been released on interim bail by the order dated 26/2/2020 and also parole. And on none of the occasions he has flouted the terms and conditions of the order. And therefore he may be granted interim bail for something. The land council for the state, we are recording that you have no serious objection.
Only condition that he should not flout any
The
condition.
land council for the state submits that the petitioner should not allow the terms and conditions of the interim bail. Considering the submission made by the land council for the respective party, the grounds taken in the interim application, the report furnished by the IAC Swanson, and the fact that there is no adverse report against the petitioner who have misutilized the liberty either in interim bail or in parole. We are inclined to release the petitioner on interim bail for a period of 1 week from the date of release, subject to condition that the servant involved in any criminal activity, servant prior to coming in contact with the family members of the deceased, and the IAC of Rashul Police Station shall keep usual over the activities of the petitioner while on interim basis. Matter be listed on such and such date, if the land council for the petitioner shall file the surrender certificate in the meantime.
May I pray, my lords?
Yeah.
That copy may be granted in course of day and it may be uploaded also. And can an observation be given, my lords, that the sessions court will act on the uploaded copy if I don't get the
No,
copy?
Giving it today itself.
Item 32.
Lords. Sir, this is an interim application. Interim application I had filed, my lord.
The father-in-law has died.
My lord. And
He asked you to.
My
ten instance.
yesterday the letter was issued to the IAC. I have not received the instruction, but can you have glanced to the certificate given by the Sarpanch? The father-in-law of the petitioner is Sheikh Sultan,
Yes.
son of Sheikh Moizuddin. Can you have glanced to the judgment?
So Mr. Counsel, plain and simple, we asked you, he wants that my father-in-law has died, he has annexed a document. You are given time to just obtain
My
instruction.
lord, his
You want to
father-in-law is
obtain
Budhiram
instruction.
Singh.
Now you are arguing that.
My lord, his father-in-law is Budhiram Singh.
You see, some persons are, might be called in two names.
No, no, no.
Alias name maybe.
No, no, alias no. Se taro se au gute jaga
Please
asli tar.
speak in English.
Yes, my lord. That after my lord marriage, my lord, he sometimes he stayed in another district in Balasore and married to a Adivasi girl. That is why he's. Yes, my lord.
My lord.
Okay, IA number 4 is an application for interim bail. The ground has been taken that the father-in-law of the petitioner has expired on 17/2/2025, and the 40th day ritual is to be observed on 28th.
Today.
28/5, and therefore he may be released on bail. The reliance counsel for the state submits that through inspection was sought for, but he is not able to get the inspection. Since the ceremony is to be held, the ritual is to be held today, the consent.
Jail authority, my lord.
Jail authority shall take the jail superintendent shall hand over the custody of the petitioner to the IIC of which police station?
Singla police station.
Singla police station.
Singla police.
Where you are now, languishing,
And Balaswar Jal, District Judge Balaswar Mala.
what is the distance?
Distance Mala Singla around
But your address, you are mentioned that is Basta police station in the CRLA appeal memo.
Singla police station.
his
Father-in-law
address,
What's your
father,
father-in-law's house is
Singla, under Singla police.
What is the distance?
Distance, exactly I can't say, but 40 to 45 kilometers.
45. Hand it over to the IIC of Singla police station. So that in order to enable the petitioner to attend the function and the shall return to the jail authorities on the tomorrow, so attending the same group. Speak copy of the order be handed over to the Grand Council for the state for communication to the concerned jail authority and also to the IAC of the squad. We send it immediately so that we are signed. Here.
For admission item 33. May I please, your lordship?
I may be pardoned, your lordship. My lord, we are appearing for OSRTC. We received instruction today, so I'm praying for 1 week's time to file the power and take instruction.
In the limitation petition, notice has gone.
Okay. You have not yet filed power.
No, your lordship. We received instruction today, your lordship.
Please give your name so that.
My lord, Mr. Amitabh Tripathi and associates.
Just write it. So, Mr. Amitabh Tripathi and council, mention is made on behalf of Mr. Amitabh Tripathi and council that he has instruction to appear for the respondent OSRPC, and he may be given some time to file the wakalatnama. So also the objection to the delay combination of this matter. 7th April. 7th April, you will file the wakalatnama. So also that I have received a copy of that.
Yes, already sent through postal.
Copy of the already received by Mr. Here.
Item 34, obligement.
May I please, your lordship, I appear virtually. My lords, this is a petition where we have challenged the impugned order, which has been passed by the Service Tax Department, and thereafter a recovery notice wherein my bank account has now been freezed, my lords. My lords, I am a practicing advocate enrolled with the Bar Council of Maharashtra and Goa, my lords. The complete proceedings were ex parte, my lords, and no orders, no notices, letters or orders were received by me. And thereafter, a recovery action was taken against me, due to which my bank accounts now are freezed. Hence, the petition was filed, my lords. My lords, the pleadings in these matters are now complete. And therefore, it is requested, my lords, if it can be taken up for disposal, my lords.
Lord, here, the ex parte order is challenged, my lord, and he's never responded in notice. Therefore, my lord, the department is not aware whether he is an advocate or not. So therefore, your lordship see section 65. There is not.
He's appearing in person.
No.
No, my lords. I appear for the petitioner, my lords.
Your lordship see the section 66 capital.
You want it some other day or you want to argue it today?
My lords, I can argue it today.
May I suggest one thing? Subject to.
Given an opportunity, let them produce all the documents.
That is therefore when I request he may appear before the appellate authority, the adjudicating authority, place before that whether he's a, and everything that.
My lords, the respondent
Yes,
number three.
I'm quite aware of that. I'm conscious of that. But
My lords,
we
the
don't have
respondent
any
number three, who is the
document we
adjudicating
don't have at the time
authority.
of adjudication. That is what our problem.
The adjudicating authority in his counter has already accepted our proposition, my lords. There has been no counter towards our proposition.
These the difficulties, the department says that since it was ex parte, we don't know whether you are a practicing advocate.
My lords, please see how. My lords, the reason is
saying that those documents are to be produced. Have you annexed a copy of your ITR?
Yes, my lords, we have.
Where,
My lords,
where you have annexed?
My lords, it's in my rejoinder, my lords, at page number 16, my lords.
No, 16 is a judgment.
My lords, we have also filed a rejoinder.
It's a part of the pleading, sir. I'm just trying.
Sir, in my pleadings, I have annexed the tax credit statement as well as Form 26A AS and Form 16A, my lords. At Annexure 5 and Annexure 6, my lords. My lords, Annexure 5 starts at page number 38, my lords.
The documents have been given here, but obviously you have to verify whether these are authentic documents.
Yes, that is what I'm suggesting. So lordship direct that can appear and place all the document. Because he is saying that 94J is profession. What profession is it can be
my lords, my lords may
whatever he has a document here, my lord, in the writ. But before
my lords, please see Annexure 1, my lords. I have enclosed my Bar Council membership, my lords. I am enrolled with Bar Council of Maharashtra and Goa, my lords. And in fact, in their counter, they have not counted any of these annexures, my lord. Their only reason in the counter is that since no one appeared on your behalf, and I will and my lords, may please allow me. The only reason for the ex parte proceedings is because they have posted each and every letter, notices, and order to an address in Raurkela where I don't reside, my lords. I reside in Maharashtra, my lords, in Mumbai.
So you will not stop in arguing the matter. You know that what we have discussed and what the learned counsel also said.
I'm helping him.
On arguing and arguing. He is ready that an opportunity is to be given to you. In spite of that, you are going on arguing the matter.
My lords, my short point is that, my lords, since now the pleadings are complete in this matter and he has not counted any of these documents which are on record, it may be simply dismissed, my lords.
So we are dismissing your writ petition. You have prayed for?
The notice should also be, my lords, the order should be dismissed, my lords, for the reason that
Order should be dismissed. Then what will be the consequence?
Which documents are you, which order you are challenging here?
my lords, the order is at Annexure 4, page number 33, my lords. In fact, my lords, this action is itself covered by our own judgment, my lords, in the case of Devi Prasad, my lords, whereby a circular was also issued by the state government of Orissa, my lords.
Which page number? The order which you are challenging?
The order is at page number 33, my lords, Annexure 4.
Read application.
Writ petition, page number 33, my lords, Annexure 4. My lords, may please see first page, my lords, where...
Counsel, have patience.
Sure, sorry, my lords. Apologies.
Judgment has been done or not?
Yes, my lords, it has one attachment issued, my lord, not withdrawn, and one attachment notice.
Have you attached the bank now?
Yes, ma'am. Because this court, honorable court has already given protection to him, lord.
What?
Protection has been given not to withdraw, lord. Stay has been granted so far as the adjudication order is concerned, and one.
That you shall not withdraw.
Yes.
So can we dispose of on that?
Yes, yes, that I'm saying, I was just saying that he may.
We can dispose it off.
Yes, you'll also direct him to appear before the authority, explain the.
Authority. And,
Yes, yes.
All the
Yes.
documents and.
Yes, yes, that is what I'm helping you out, lord. Without recording a consent, lordship, they pass that on.
The assessment has been done by the central, the assessment commissioner, the central tax, listing and the central excise. Roundkela one, Roundkela. Demanding, imposing a penalty of rupees 7,22,100. Upon the petitioner. But it was reduced to 1,80,000. It will reduce by 1,80,000.
No, that is what penalty under 78.
Okay.
There is two type of penalty. That's even here, tax and penalty.
Okay, tax and penalty.
Yes.
Imposing a tax and penalty for non-deposit of the GST for the services.
Service tax.
Service tax.
Non-deposit of the service tax for the services so rendered. According to the minister, he is a practicing advocate, and therefore is not liable to pay the service tax, as such services are exempted or kept outside the purview of the relevant statute. The counsel for the department fairly submits that since the proceeding was initiated ex parte, the authorities were not aware as to whether the petitioner is a practicing advocate, and therefore proceeded to adjudicate on the basis of the show cause notice should remain unreplied. And an order of attachment has also been issued. In course of the proceedings, it appears that the interim order was passed by this court, restraining the department from realizing the amount for which the said notices were issued until the final adjudication of this writ petition. The quick and substance, as it appears from the respective stands, that an ex parte assessment order was passed. And obviously, the authorities was not apprised of the fact whether the applicant is a practicing advocate or not. So as to make him outside the ambit of the service tax applicable in this regard. It is fairly certified by the department that if the petitioner produces all the relevant documents in support of the contention so raised in the instant writ petition, the authority will consider the same and will pass a reasoned order in accordance in presence of the petitioner. In view of the stand having taken, the order included in the instant writ petition is quashed and set aside. The petitioner is directed to appear. Can you give? We will fix a date here so that no further notice is required to be served.
But your lordship fix a date, you appear and then.
That is what. So when you can go, you are in Goa, you have to come in Raurkela.
We are in Bombay, my lords. We can appear at any time, at any time convenience of the department.
Mr. Counsel, tentative date, give a date, a firm date, not tentative.
Next week, any date at the convenience of department, my lords.
So we are fixing which date? Oh, April is here. So next week, can we fix on 11th?
Yes, my lords.
Yes?
Yes.
Friday, you can have the 2 days, Saturday and Sunday.
Yes, my lords.
So what has said? Appear before the authority on 11th April. At what time? 12 noon?
Yes.
Yes, my lords.
At 12 noon. And will participate in the hearing. Stop. It is the liberty is granted to the petitioner to produce all the relevant documents in support of the contention so raised in the instant writ petition. And it is open to the authorities to take a conscious decision thereupon, taking into account the veracity and the genuinity of the documents relied upon by the appellant. The entire proceedings shall be concluded by the authority within 3 weeks from the said date. Since the bank account of the petitioner has already been attached, it covers the entire amount of demand. Yes, is attached. The petitioner shall be at liberty to operate the said bank account, keeping an amount as demanded in the said account. Above all,
Yes. Much
obliged, my lords.
The writ petition is in all disposal. Which one?
Item 35. My lords, this is the tax. The state has to give me a counter reply for that. So it's the cases of the GST Act. Under the GST Act, it was a.
You want adjournment? Praying for
No.
3 weeks time.
3 weeks time.
To
Sir.
file counter.
To counter.
Alliance Council for the Union of India takes 3 weeks time to file counter affidavit. this matter, such and such, after 3 weeks. And count will be filed in so and so, and reason we will on it thereafter, matter will be listed, then इसके बाद. Yes.
Item 36. May I please allow? And last take a notice, sir. Last occasion notice was issued.
Is a condonation. What is the delay of?
Till
How
of
many
my lord,
days?
56 days.
Oh, you are for the appellate?
I am for the appellant. It is a inter-court appeal. It is filed by the bank.
Any objection?
My lord, 56,
Filing objection. No
I will
objection.
file objection. I will file objection.
How many days delay?
56 days, my lord.
What?
Maybe
And they are the bank authority.
In fact, it is not 50, what is the delay mentioned? That there is a note 31 days.
No, they have said it 31.
30 days. Why are you telling 51 days? It is.
And my
limitation is
calculation
30 days.
30 days.
My lord, without recording my concession, this may be controlled.
Sir. Sir. हाँ सर वो हाँ पहले यही होता था लेकिन अब वो
Computer slip.
Anyhow, it's not there. Huh?
31 days. Sir.
Second. Yes, what do you say? 31 days?
My lord, without recording my concession, I will control.
My learned friend is fairly submitting that without recording his concession.
IA number so also there is an application for confirmation of data which now we put as pointed out. There is 31 days delay in filing this read appeal after hearing the land council for the respective parties and reducing the grounds taken in the interim application. We are inclined to condone the delay according to the delay is condoned. IA is disposed of read appeal is placed of admission on anyone.
Next week, no.
7, 8, 9.
Okay. Any go.
We have small grades.
Since the opposite party employee has entered appearance, she is the sole opposite party respondent.
So you want a service of notice to be dispensed with?
Exactly.
So you can report the dispensation.
The since the respondent with the land council has already appearance for the
Sole respondent.
name.
My lord,
Let a copy of the record will be served on the land.
already, sir.
Already served.
Already sir.
Already, sir. I have the.
Notice jaitala both way. In read appeal as well as in the.
Limitation, so that is why we asked that.
I have already.
The read appeal.
Exactly. That was the order.
So for the notice of appeal.
Item not 37. May I pray that improved order be.
No, let it come on, sir. We do not know what is the.
7.
On that.
Lord, it is 7.
8.
The blue line.
Obliged.
Item not 37.
Here, dispute is under the CGST Act. Here, petitioner is a government of Orissa undertaking.
Your Lordship, kindly have a glance to the last order dated 6th March 2025.
Which order?
6th March 2025.
Yes.
Yes, my lord.
Paragraph
In the-
3.
Your Lordship, it is,
In-
because
in this
no
matter-
grievances against state revenues.
My lord, may I?
Central revenue.
Yes, may I submit, my lord? May I submit? The impute is the so-called notice issued by the Director General of Goods and Service Tax Intelligence. And it is under challenge. I am appearing for the opposite party number 1 and 2, 3, my lords. So far as the opposite party number 4, that is the DGGA Director General, Mr. Satpathy used to appear. So a copy of the writ petition may be served on Mr. Satpathy so that he can reply back on the so-called notice.
By your side.
I'm sorry.
Let's start a copy. I'm taking steps.
The interim order will
The order is still.
next date of hearing.
Next date of hearing today.
You are appearing for the joint director.
Yes.
Directorate General of Goods and Services.
Yes.
4, 5 and 6.
Mr. Satpathy, Senior Standing Counsel for Swanson, submits that he has instruction to appear for opposite parties number 4, 5, 6.
Yes, 4, 5, 6.
7.
4, 5, 6. Copy of the writ petition has been served by the Land Council for the petitioner on Mr. Satpathy in court today to seek some time to obtain instruction. When we put up.
2 weeks time.
2 weeks time, yes, sir. With this matter, that is for Sangram में रखते हैं इसके बाद 16th of April.
Yes, yes.
2025, interim order dated 6/2025 is extended till next week.
Please to mention, my lord, very pardon. They mentioned item 35, the interim order to continue, my lord. That it was granted earlier, so that is to continue, that it was for the next.
There is an interim order in item number 35.
Okay, we don't know. Interim order is there.
Yes, that is to continue, madam. 35.
Who is appearing in item number 35?
One of my colleagues is appearing so far as the GST department is concerned.
So let him come and say.
Yes, ma'am.
Interim order में Excise है. इसका date है 7/3.
Yes.
Interim order to continue.
Please inform me.
Yes, ma'am.